Arellano, and she is an employee of the Worksman Jackson firm. And it's important to who it's addressed to. 2, the first name on it is Hank. That's the first name on it. To Hank, Mary Ellen, Adam, and 9 more. Good afternoon. The Dropbox link below contains ARCA reciprocal discovery. Please let me know if you experience any issues accessing the files.
Okay. What time of day? Because if it's California time, it might be different than what we have here. But
It probably will be, but I don't know what time of the day. I'm going to ask the team if they can access what time of the day, because I don't know the answer to that as I stand here.
okay.
All right.
And so, but suffice it to say that the hearing was on the 18th. So it wasn't like it was a Friday, and then we're back in court on a Monday. My best recollection, the calendar will be the best evidence, is that this was toward the middle of the week, right? But in any event, let's say worst case scenario, it was dispatched at 9 o'clock at night, California time, which would be midnight Eastern time. And let's assume worst case, it's therefore in effect the 14th. That's 4 days before the 18th that this is sent. And
Do you have a time?
Pardon me?
Do you have a time, Ms. Little?
Yes, one moment.
Thank you.
And I'm understanding Your Honor would like me to pause until you get that.
If we can, because I'm looking at a
Absolutely.
calendar. If you don't, I thought you may have had it. We can move on.
I think it's approximately 6:30 in the evening. It was received by the Commonwealth.
Thank you.
And is that, may I ask Your Honor if that's Eastern time, 6:30?
Eastern Standard Time.
Thank you, Ms. McCall.
And Your Honor, it was a Thursday.
I'm sorry.
It was a Thursday.
Okay, thank you.
So also, in big bold letters, at least on the printout, the subject is Karen Reed-ARCA reciprocal discovery. It's not like it was buried what was being sent. I mean, this was a lot of things, but it's right there, ARCA reciprocal discovery.
Was it just these pages that we've been talking about, or was it a lot more discovery?
May I confirm with counsel? I think I know the answer.
It was just the pages, Your Honor.
Okay, thank you.
So it's not like ARCA is amidst a sea of other topics, right? This is the driving force of the email. And so, Your Honor, the question, and I'm going to keep moving on, but the question becomes, and I'm going to ask it more than once, but hopefully not too much, how is it that the Commonwealth on the 18th understood incorrectly, I think it's undisputed it's incorrect, that they got these materials from the federal government? We don't know the answer to that question, but I respectfully submit it's an important question. Was it an honest mistake? Was it just, as happens sometimes in lawyers working together, there's a lack of communication, there's a miscommunication? Is that the explanation? But I think truth and justice on these topics, since we're being so exacting and appropriately so, we should have an answer to that question. So we move on to page, so there we have on page 58, we have another incorrect statement. We have 2 of them right up off the top, and then we continue on to page 59. Your Honor, understandably, says the court. What is the date of that? Mr. Brennan, it's not dated.
When I said it, what was I talking about?
I believe, Your Honor, you were talking about the outline.
Just give me a second. Let me make sure.
And Your Honor, if I may, I want to give you the second, but the basis for that answer is page 58, line 7, where the statement is, and what follows is all about the outline.
Okay.
So, Your Honor, appropriately and understandably says, what's the date of that? Here's the answer Your Honor got. It's not dated. It's not dated. Now, let's please just go back to tab. We're talking about the outline. let's go back to the outline. And we could pick either one. I'll pick perhaps the most probative one. I'm not going to refer to the tab because Your Honor says you have these. This is the June 23rd email from Daniel Wolf. I'm just pausing to make sure
I
you.
have it.
Thank you.
It's what I refer to as a script, right? That's what you're referring to?
That's what Your Honor has referred to it as.
Yeah.
Subject-
So that itself is not, I understand it's with the email, but it's not dated.
Well, Your Honor, I was going to get to that, but there's context for that.
Okay, go ahead.
The context, you're correct. The outline itself is not dated. However, the attachment, keep in mind, we produced these materials.
Okay.
So we deal in e-discovery all the time. And when you look at the attachments, everybody relies upon the attachment line, especially if it's a Word document. So it's wolf_direct.docx. So you know this email has an attachment. We fortunately have a file named direct. Your Honor has referred to it as a script. There is no other document that was produced that comes anywhere near close to this being the direct. So I don't believe there's any reasonable basis other than the other email on the quals that came the day before, 2 days before, the day before June 22nd, which has the same attachment wolfquals.dcx.
Can I ask you a question just
Yes.
because I don't understand? So what I have separately is the script and then something saying qualifying the expert. Is this all one document?
No, Your Honor.
All right,
And
so
I appreciate the question.
What
So-
is the date of the, so you're saying what I refer to as the script was sent on the 23rd?
That is correct, Your Honor.
What was the other one?
The
When
other
that
one was
sent?
sent the day before on June 22nd.
Okay.
I'm just going to give it the name that the email has. I think it's apt. Wolf_quals document. Okay? So there's two emails. One's just the quals. The other, respectfully, Your Honor, I know what you're calling it. I'm just going to call it what it says.
Sure.
The title is direct. So it doesn't matter which one you're talking about. To me, it doesn't matter whether there's a date on the actual quals document or the direct document. We produced them in this fashion, and I believe the only reasonable conclusion is that the outline is what is sent under the June 23rd email. And Your Honor, the reason why I persist in this is because if Your Honor goes and looks at the, and this is important for the context, if you go back to the June 22nd email,
Okay.
the last sentence is, I will try to work on some direct examination questions tonight. Today, our conclusion to make is that direct outline was created after the 22nd, or on the 22nd or after, and certainly by the 23rd. So that's what the Commonwealth had in terms of the information. So in conclusion on this point, but I think an important one, it's not dated, but here back to you, Your Honor. The TURI request is a recent February response, but they, and I'm assuming the Commonwealth meant the federal government, send random documents. There's no real accounting. But there is an accounting on the face of the emails that I
Wait,
just
actually,
went through.
hold that thought. I just have one other thought about
Yes,
this.
please.
So we're talking about Saturday, June 22nd, what was sent as an attachment with the email, and Sunday, June 23rd. So this was before the witnesses testified, right?
That's
And you are
correct.
saying saying that this was disclosed prior to the February 18th hearing, but was this disclosed prior to the witness's testimony?
The answer is no, Your Honor.
All right.
The
I
answer
just
is-
wanted to be clear, that's how I see it. I just wanted to give you the opportunity to tell me if that's not accurate.
No, that's 100% accurate.
Okay.
And I'm going to get to that. To me, that's a Rule 14 issue, not a candor to the court issue.
Okay.
So now, if we could please go back to page 59.
I'm there.
Thank you. There's no real accounting. Now, I'm not saying that undermines the conclusions of ARCA. There's another okay, so to speak, with ARCA. Or I'm not saying they're not qualified witnesses, but it certainly shows some bias. I went over a lot less, blah, 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 blah. Now, here's the next one. Another comment. He's quoting, would it be fair to say, because you had a lot of nighttime visibility work, your cases frequently involve pedestrians. Now, and then yes, unfortunately, there is a direct correlation between the time of day and pedestrian facilities. Statistically speaking, most pedestrian facilities occur during the evening.
Fatalities.
I'm sorry, thank you. Fatalities occur during the evening and night hours. End of quote. And then the Commonwealth adds a commentary. That would have been nice to have. They had it. They had that. What's the objective evidence that they had it? I go back to the voir dire. They had it 4 months ago. 4 months before last Tuesday. They had it before we turned over the discovery. And what's the objective evidence that they had it? Is the voir dire of June 18, 2024 of Dr. Wolf that I referred to earlier, page 167, line 12. This is Dr. Wolf. Well, to give you an example of that, so I do a lot of nighttime visibility work where, for instance, let's say a pedestrian is coming down to the roadway, etc., etc. But that's not the end of it. They had it twice. So if we go to the direct testimony of Dr. Wolf that I referenced earlier, this is my tab 6, but I'm going to stick with, it's the date of June 24, 2024 of Dr. Wolf. Page 36-65.
Okay.
Line 22. This is Dr. Wolf's answer. Several hundred, period. As I mentioned earlier, you know a great deal of my work is in the field of lighting and visibility. Here comes the key points. So there is a direct correlation between time of day and pedestrian incidents. We see a rise in the evening and night hours just due to drivers having a difficult ability to try to perceive and recognize individuals. So I certainly see a lot of pedestrian collisions in my casework. There it is.
I did see that.
So let's go back. That's misstatement number 5. The end of the quote, and then the Commonwealth takes on with a commentary. Pretty important stuff in this case. I agree. And you had it twice. And then he comments, if you don't want me to say this, that's fine, that's fine. Then the commentary from the Commonwealth. Shh. And I went back and watched the video. Shh. Don't tell them. I'm sorry? What do you mean don't tell them? You were told twice. In the voir dire, and in the direct, it was just unvarnished. And here's the important part, Your Honor, another important part. Mr. Jackson drew that out on direct. Not only was he not shushing or hiding, It was Mr. Jackson's question that drew that out. So here you have Dr. Wolf trying to figure out, is this something that we should say? We're not. And honorably, Mr. Jackson, no, we're going to hit it head on. Mr. Jackson draws it out, puts it right on the table. 4 months before February 18th, and the whole world heard it live. Next, if you could, Your Honor, please go to page 60. I'm sorry, there's another point at the no, let's go if we could. I don't want to take the lesser significant ones. I want to focus, because there's many of them. I want to get to the more significant ones. So then we have on page 60, line 2. And then a bill from ARCA to the defense for $23,925. That's not a trial by ambush. That's getting duped. So I, Attorney Brennan, didn't know any of this. But I've tried a few cases. I've been around the federal court a bit. I know how it works. So what is the import of that statement? I didn't know any of this until I got it from the federal government. And we're talking about the invoice. No. You know about it because the defense, after the certificate of completion of discovery, in 6 weeks before the trial is starting, the defense affirmatively turns it over and does it not buried amongst several discovery documents, but essentially a tailored discovery response that's titled Karen Reed ARCA Reciprocal Discovery. That's not a very good way to try to cover up something. There is no statement about the date of the invoice on February the 18th. So people are left to wonder, when did it occur? When was this bill stated? The date's important for that invoice. Then there's a lot of statements made, sometimes parties pick sides, agree, blah, 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 and then it allows the ability of one side to use ghosts. They create illusions and shields and say something's there and something's happening, a federal investigation, and this person, and then this happens. Your Honor, I think it's important for the defense to be allowed to speak to the very words that were used against us. Ghosts, illusions, shields. That's what we're accused of. I choose to try to comport myself and practice a certain way and give people a little bit of the benefit of the doubt. But if we're going to be talking about ghosts, illusions, and shields, I don't think it's the defense that's creating ghosts, illusions, and shields here. The illusion, and it's more than illusion, it's a statement of fact, is that all these documents came from the federal government. It's not an illusion, it's a statement of fact. Statement about federal investigations that were these are not ghosts. We're not creating it, but I'm not going to go any further on that topic. But the ghost word was used, in my view, the way I read it was, these topics we're making up, right? And we're hiding things, shield, right? We're shield, I interpret it as, you're preventing us from getting this information, defense. And this is 5 days after we had provided it. Next line. Page 60, line 13. I don't care if the ARCA witnesses testify at trial. I'm very pleased to hear that. I don't care about their opinions. I'm pleased to hear that too. But I care that it's unfair, imbalanced, and hidden. Hidden. And that is based upon the faulty premise that we didn't turn it over and the Commonwealth got it from the government. There's no other way to read it. And the Commonwealth, like the defense, is entitled to discovery. I agree with that. The Commonwealth is entitled to discovery, and you got it 5 days before February 18th. Now comes to the court. All right, I'm going to take a recess. And I certainly, Your Honor, am not going to be so officious as to even delve into why Your Honor wanted to take a recess. But I will tell you what I thought and what I believe occurred. Your Honor listened to a completely counterfactual rendition of some of the most important issues of the day and, frankly, of the moment in this trial. And the reason I've got a little bit of an inkling is because what happened when the court came back. So what I concluded, after all of this and the court staying a break, is, after all of these inaccuracies and piling on of inaccuracy after inaccuracy, there's a cause and effect in my mind between the several and serial inaccuracies, the break right in the middle, and then the court comes back. And I understand, I don't really, and I'm going to get to this, see the justice in terms of this presentation to the facts. And that's what we're going to be talking about, facts and representation. So here's what the court says. After hearing all of this, and I want to underscore something, Your Honor, and I'm not going to get too lofty with due process and notice, but it's important to hit some of these points. All of these topics that were raised were not in a motion. They were not in an affidavit. And I've had this issue before with other motions under what's required in an affidavit. None of
In this case?
No,
Or
I'm
you're saying
talking
generally, you've had this issue in other cases, or do you mean this
other cases, Your Honor. With there not being an affidavit, right, where someone's got to be very, very careful about what they say. But in this information that Your Honor had to be subjected to was not in anything that we had notice of, these topics. We had no notice that this was coming. There was no affidavit that someone had to swear to that all of these facts were correct. And Your Honor takes the break, so we didn't get an opportunity to stand up and say, what I'm being given the very fulsome opportunity to say today. So Your Honor comes back. All right. So the Commonwealth just provided the court with information, and I don't even want to repeat these words because it almost pounds on to the prejudice to the defendant, but Your Honor well knows what Your Honor said, but it certainly had the words in there that were very, very difficult on the defense. And you say, so for that reason, right? So the Commonwealth just provided the court with information that causes me, and then it goes on. So it's clear that Your Honor was relying upon that information, which was only given verbally, right? And you say, so for that reason, I'm going to suspend today so that we meet again, and then the rest, so be back in here. Unfortunately, that's not the end of the prejudice. So what happens is, all of a sudden, and Your Honor basically said, and this is all so key, so you said, I'll see you in a week from today, and then Your Honor continued on page 61, line 12. And where Mr. Brennan, where the federal authorities have been kind enough in the past to allow me to have copies of everything, would you be kind enough to call over there and check with whomever you were dealing with so to see if I can, in fact, get a copy of everything that you just read? It was only then when the the reality hits that you're looking for the backup for what's being said. Up to this point, Your Honor's understanding, all of this came from the feds and the defendant didn't turn it over. So what does the Commonwealth do then? Does the Commonwealth stand up and say, whoa, wait a minute, I made a mistake. And Lord knows I've made mistakes before. They didn't stand up and say, a very significant mistake, my whole predicate for my whole presentation was, I had to even fight the feds to get this information. Lo and behold, I got it, and I've been duped, and I've been ambushed. Rather than saying that, and you know what, I don't even know if I would have had the courage to say it in open court, I might have asked for a sidebar and come up and said, Your Honor, my bad. You know, this is that. But that didn't happen. So what did happen? The Commonwealth says I can, and there's a brief chronology I think Your Honor should be aware of. So the defense is still not able to get up, but the Commonwealth is continuing on. If I could add that right now, it will take me less than a minute. The court, okay. So the Commonwealth goes on, says the chronology is December 4th. We sent another TUI request, 2024. January 6th, we filed our notice of intention to exclude ARPA experts. January 30, 2025, the United States Attorney's Office sent a response to both ours and the defense request. Without any prompting on February 6, 2025, the defense and the prosecution received an email from the U.S. Attorney's Office saying that the contract had ended with the ARPA experts and that if either party wanted to engage, the original materials are still protected. This was a change in position about whether the party could be impeached. On February 11, we filed a motion to exclude. February 13, the defense provided us the emails that I read. Buried in a chronology is, and in the middle of a sentence is, the defense provided us with the emails. I think I said, I'm going to repeat that. I think I said, the federal government, it was the defense. February 13th, they sent us the emails and the direct examination outline. I think I said. That was the whole basis for the entire presentation, was that the Commonwealth had to fight, needed the feds to get that. And then it goes on. We reached out to the federal government, but you know what was not said in lines 9 through 14? What was not corrected? It wasn't corrected that the invoice came from the defense. Just emails.
I thought it meant everything, but...
I don't understand how that conclusion can be drawn, Your Honor. It didn't say the defense provided us with all of the entire production. The defense provided us the emails that I read. There was no email with the invoice. The invoice was discussed as a separate item, and I can go back to it. When the Commonwealth was talking about it, they never connected it to the emails. So then we reached out to the
because I received a copy of it.
Pardon me?
I think it's because I received a copy of everything that had been referenced.
Yes, but I'm going to get to the point about the importance of correcting misstatements, because 3.3A1, everybody focuses on the first sentence, which is, thou shalt not make a false statement of fact to a court. The second part of 3.3A1 is you get the opportunity to correct, you've got to correct a material. And I've got it in front of me, but I'm just paraphrasing. I want to get to precisely. But that's why I perseverate this on this, Your Honor, because I trust that the court's going to hold everybody to the same standard. And so I think there is a proper inquiry. I don't intend to be officious as to what the court should do, but if we're going to start looking at comments of defense counsel, I believe we have to look at all comments. And again, I'm going to go back to my own view is this. Being a lawyer in cases like this is hard. Being a judge in cases like this is hard. Mistakes are going to be made. So we go on into page 62, line 15. We reached out to the federal government again because I was curious about the change in position on February 6th that the contract was ended, but that parties could contact ARCA. Obviously, the Commonwealth is in no position to contact ARCA because that would naturally preclude the defense from retaining them. So we refrained and we will not reach out to them. This is really an interesting statement because you read it because that would naturally preclude the defense from retaining them, yet at the same time the Commonwealth for the fourth time has moved to strike our ability to use ARCA. So then the court goes on, all right, so the information that was provided to you, not from the federal government, so Your Honor knew at that point, I don't believe Your Honor had any basis before that to believe that it had come from the defense. I'd like a copy of it before you leave the courthouse. So I hearken back, Your Honor, to what I conclude drove Your Honor to make those impactful statements about, on the top of page 61 was the presentation of the Commonwealth that I counted had 10 misstatements. 10 before Your Honor caused the pause. So, coming to what happened then. The Commonwealth, having not giving us notice that this was coming, these topics, not putting any of these statements in an affidavit, we didn't have the ability to stand up. But I will tell you this, Your Honor, I greatly appreciated the week that we got, because I do believe that Your Honor intended that counsel be given, defense counsel and defense, a fair opportunity to go look at this. And that's the way I'll speak for myself. That's the way I took it, and I appreciated that. Because that's allowed me to go spend the time that I spent to try to do my level best to give the court an accurate rendition of the fact, because as an officer of the court, I believe that is a sacrosanct duty. And in a matter where the very issue is, what are counsel saying to the court that isn't accurate, I wanted to make sure I could do the best I can. Now, I may have made a mistake here or there, but I just want, but I want to make sure that I recognize Your Honor's giving us that week, and we've tried to take the best opportunity for it. So what happens? What happens after these 10 misdirections? The court's comments go viral. And I'm not saying this for drama's sake. I'm saying this for what has impacted the defense 6 weeks before trial starts, while jury notices are out in the mail. Those words, based upon the misdirections that your court had to endure, have gone through, and I'll just name a few headlines in the Globe, the Herald, every TV outlet, social media exploded. And these are not trivial issues. And more than that, the veracity of counsel has been called into question. There's commentary of everybody about what's going to happen to certain members of the counsel's team, and whether it's intended or collateral damage. We've got the ARCA experts, which are key parts of our case. Their credibility is being pillared throughout the public domain. And this could have been avoided had there been an accurate recitation of what had occurred. And Your Honor, I don't know if this can be remedied. But it surely shouldn't have been exacerbated. I would now like to move rather, hopefully, efficiently through the next step, which is to point to the Massachusetts rule and give the court my view, and I have to reference, because Your Honor brought up some...
You don't have to tell me what you're going to do, Mr. Leslie.
I'm sorry, I'll just go ahead and do it. My apologies. So now let's just turn to Model Rule 3.3A1. And this applies to every counsel in this room, of course. A lawyer shall not knowingly, so there's the adverb of the mens rea, knowingly, make a false statement of fact or law to a tribunal, or fail to correct a false statement of material fact or law previously made to the tribunal by the lawyer. So we all know the mens rea of knowingly. And this court knows it better than everybody, so I don't have to get into that. But in terms of make a false statement of fact or law to a tribunal, I don't see that on behalf of the defense, and I'm going to get to the new item of February 6th, since we haven't covered that. Your Honor brought that up today. But certainly with regard to the representations that I've gone through and the statements that were made, especially on June 10th, they were 100% true and accurate at that time. They were 100% true and accurate, and that's why I went through the notebook. Or fail to correct a false statement of material fact or law previously made to the tribunal by the lawyer. And there's no real time period that's given for the attorney. But here is something very important, Your Honor, and I'm going to parse the grammar because it's what you do in construing a statute. It says, or fail to correct a false statement of material fact or law previously made to the tribunal by the lawyer. So the is a definite article. So it's like an adjective, it's a definite article. Lawyer is the noun. The lawyer refers to the lawyer who is perhaps made a false statement of fact or law to a tribunal. So it's sort of like you make a misstatement, it happens, but you got to correct them, right? And what they talk about is, what do you have to correct? You have to correct a false statement, so it has to be false. It has to be knowingly false, of material fact or law. And material has been interpreted in the context of 3.3A1 to be a statement of fact or law that caused a court or adjudicator to have relied upon it for a determination. It's essentially what the case law talks about, that it's influenced the judge's decision. So let's go back and even let's assume hypothetically that on June 10th there were misstatements made. It's not any misstatement. It has to be a failure to correct a material. You have to do it knowingly, and then you have to fail to correct a false statement of material fact. And in terms of what Your Honor had, it's the same lawyer that we're talking about in both clauses. And that is why I spoke about Mr. Yanetti's statements on the 10th, about what he knew, the fact that Mr. Jackson was handling the ARCA experts. So it's important to be analyzing what lawyer is saying what and which lawyer is to be making correct to correct the statements. So I go to the analysis with regard to 3.3A1, and as I said, I'm keeping separate 3.3A1 from Rule 14 because they're different analyses, as the court knows. But I want to hit one of the most important ones first. So there's not a false statement of fact or law to the tribunal, and I will stand here as long as Your Honor needs, if Your Honor feels differently based upon what I've said. Or fail to correct a false statement of material fact. So what I'd like to do, Your Honor, is now go to what Your Honor brought up today, because I was prepared for the June 10th. I wasn't prepared for the February 6th.
Do you need time?
I don't. I have taken the time. I appreciate the offer. But I would like to draw your attention, Your Honor, because like I provided context on June 10th, I think context for February 6th is important. And so what I'd like to do is to go back earlier than what Your Honor quoted this morning, because I think the context is important.
All right, so I have that entire transcript, like I said.
Thank you.
What page are you at?
I am starting on page 40.
Okay.
I start with line 1. Mr. Brennan, correct. I had a conversation with one of the two prosecutors I spoke to, and the only means of trying to obtain information they suggested was through a TUI request. I don't think it's the Commonwealth's obligation to seek discovery, part of Rule 14, but I wanted to assist the best I could, so I made an assented to request, and they responded with a letter. I think you received a copy of it. Do you mind if I share it with, no, okay, I received it, I sent a TUI response, essentially rejecting all of my requests on multiple grounds. So to be fair to the Commonwealth, Your Honor, this is February 6th, and they haven't gotten our discovery, right? They're just still trying to get it from the government. They don't have it from us yet. The court, all right, can I get a copy of this? If not, I just need, and then, Ms. Bugalton, you can retain that copy. Thank you. So I'm not going to stay here and read it right now, but all right, Mr. Brennan, of course. And so inevitably, I'm not making any motion right now, but I appreciate that as the proponent of the evidence, defense's obligation to give Rule 14 discovery. I do not think, even despite their testimony, they complied with Rule 14, and so the reason I forecast this was because I appreciate the April 1st trial date. If the defense, through no fault of their own, is unable to comply with the discovery, I think that we're entitled under Rule 14. I will at that point move to preclude the witnesses. So I think the important in this snapshot in time is all of the discussion that occurred on February 18th, and I'm going to underscore this. That presentation was not about the substance of what was in the email. The Commonwealth never had an issue with that. It was all about they had to get it from the federal government, and we didn't turn it over. Your Honor obviously has read the February 18th transcript. You can draw your own conclusions. But on February 18th, they were not on the issue of anything other than they thought that they didn't get the material from us. So now we continue on. The court. Move to exclude the witnesses? Mr. Brennan, yes. The court. What do you say, Mr. Jackson? Mr. Jackson, I don't want the witnesses excluded. What do you want me to say? The court. I asked you all to try and work out something. The original protective order permitted that we can do in court anything that would rule. I expect you to say something a little more than that because, and Mr. Jackson, well, I'll wait to get this motion. The court, all right. Last time, Mr. Jackson, let me put it this way. The court, hold on a second. Last time we did voir dire these witnesses, it seemed to me that that was the logical conclusion. I'd be able to get both sides discovered. We did that. That seems like a logical alternative to the exclusion, right? Your Honor knows what you're doing here. I guess we can wait and see if I exclude it on a motion to exclude. It just makes sense to me to set that up now rather than wait. I don't know when they do that, when the Commonwealth, based on their witness list, recalls them, is that when you want to exclude it. So I sort of expected the defense would have some suggestion. If you don't, you don't. Mr. Jackson. And this is the key context. I can tell you this, the Commonwealth has exactly, this is an interesting and sort of different set of witnesses. The Commonwealth is saying that pursuant to Rule 14 and, exclusion and preclusion of a witness is a punitive sanction for Rule 14 violations. Ms. Reed has not violated anything. Why should she be penalized when the Commonwealth has the exact same batch of information that we have about these witnesses? And there's more context to that. I understand the import of these words so far. So I don't have any more information. I don't have any additional discovery. I didn't hire them. I didn't ask them to engage in additional protocols. So I've got nothing else to give to Mr. Brennan. He's got the same information I got and he got at the same time. What Mr. Jackson is referring to here is the disclosures from the U.S. government, not the disclosures that were going to occur on February 12th and 13th when we would get the certificate. We had the certificate of completion of discovery. We had 30 days, technically, to turn it over, but it got turned over on the 12th. So then it continues on, is important, the court, if I don't exclude it with other side seeking a voir dire, we would not seek a voir dire because they're eminently qualified and there's no other discovery to give. They've provided. The federal authorities provided all the discovery that was attended to their analysis and testimony. So what we have in terms, Your Honor, this is important, and I'm going to go right back to 3.3a. We have Ms. Little handling all the discovery. Mr. Jackson is not sorting through discovery, knowing what we got, not recalling what is in the possession from March 22nd, not recalling all of those items. That was Ms. Little's responsibility. So what happens? What happens is Ms. Little handles the production, goes back and does the diligence that she always does, takes all that material, sends it over to the Commonwealth. On February 18th, the defense did not have the opportunity to address the issues that Mr. Brennan had brought up. But I now want to go to the statute and why it is important. Because the whole issue of discovery, the whole issue of batches of information was provided. And it was provided before, well before the 18th, before any of these issues came up. And Your Honor, respectfully, whatever the court may consider to have been an inaccurate statement, there is no knowing misstatement of fact. Mr. Jackson has never, I can tell you this from personal experience, I don't see him ever touch one item of discovery in terms of here's what we're going to collect, here's what we're going to turn over. Never have I seen it happen. I've spoken with him, he can speak for himself. That's not, so there's, even if you take any read of February 6th, Mr. Jackson is focusing on and thinking the discovery is just what everybody has from the federal government. You've heard this many times. We can't produce more than the feds have, but we certainly, and I want to hit this head on, we certainly had those March 22nd, March 22nd, we had those emails at the time that statement was made. We had those. We had the direct. We had the clause. Not running away from that. But the question is, at the time Mr. Jackson made those statements, he's focusing on the government, and he's not knowingly saying in his mind, oh, well, I know we've got these emails from way back when, and so with regard to the shall not knowingly, there's no evidence of knowingly here, and I don't believe, respectfully, there can be an inference stated. When I've looked at every single case where the court can look at the circumstances, so knowingly is not merely a subjective question of what an attorney has. The court is entitled to look at the circumstances, and the case law says should make an objective determination on knowingly. But the cases, and I can give them to Your Honor, the cases are legion, that the court cannot draw an inference from no fact to conclude it was knowing. They got to have some basis, and I'll give you some examples. What happens is if, let's say somebody, one of the leading cases is unfortunately a woman attorney who was in a bad divorce. She had financial statements, and she made misstatements of fact about her financial statements. And then the question became, did she knowingly know it? And what the court did, she said, no, I didn't know it, I didn't remember it, I was under psychological stress. And what the court did was they went and they looked at the circumstances and saw emails and conversations she had with her accountant, where she clearly knew about those statements, and she told the court she did. So there's an example of you've got to have circumstances that the court cannot just jump from a lawyer said this to it's knowingly without some basis. That's why the mens rea is there. So in turn, and that's the February 6th, respectfully, that's the only aspect, and I went through all the others, that even comes close to a false statement of fact by Mr. Yannetti or Mr. Jackson. In sum, Mr. Yannetti's statements on June 10th, all completely accurate. All completely accurate. Mr. Jackson's eliciting of the direct testimony at trial, when he asked, have I ever asked you specific questions, etc., that's completely true because it was Dr. Wolf who sent the questions in. So we now are left with February 6th, and I've given you that construction of the statute. My last point, Your Honor, is going to go to the Rule 14, which is, and I'm going to spend a very short amount of time on this. Now that the Commonwealth knows that the discovery came from the defense, I want to go back to, please, the February 18th transcript, because I want to keep separate analytically the ARCA from defense counsel, because obviously for Ms. Reed is obviously very concerned about her defense counsel and her choice of counsel, which is going to be my last legal point. But in terms of what occurred, I want to go to and quote the Commonwealth on the transcript. I am on page 62, line 18. Obviously, and by the way, this is toward the very end of the 18th. Obviously, the Commonwealth is in no position to contact, etc., etc. And what does that relate to? If Your Honor would go back to page 60, line 13. And it's a repeat, but I didn't get to the point here. I don't care if the ARCA witnesses testify at trial. I don't care about their opinions. But I care that it's unfair, imbalanced, and hidden, and the Commonwealth, like the defense, is entitled to discovery. Key line. So, if they can produce the discovery, I welcome ARCA. I want to repeat that.
You don't need to.
I'm sorry. Okay. So my point is, we produced the discovery. Why is there still an issue with ARCA? These aren't my words. So I want to cover, before I get to the Sixth Amendment issues, the point that ARCA should be allowed to testify. We've complied with our Rule 14 obligations. There's no prejudice. They have the discovery. They've obviously had from the government a long time everything about ARCA. So I want to touch that base to make sure that either intended or collateral damage, that ARCA still gets to testify, because it's a key part of the defense here. Now to the Sixth Amendment. The United States Supreme Court has held repeatedly that a defendant's Sixth Amendment right to defense counsel of their choice is a root basis of the Sixth Amendment. Is it an absolute right? No, Your Honor. If counsel does something so egregious, does it correct it? The Sixth Amendment gives way to the need for the court to have candor, the need for the court to have decorum in the courtroom. So I understand that. My presentation today was as an advocate, of course, foremost, but also to provide all the information. So when Your Honor balances that sacrosanct Sixth Amendment right with whether or not there has been such a level of conduct that can be diluted or trumped, and I give Your Honor United States versus Gonzalez-Lopez, 548 U.S. 140, 2006. And in that case, there was violations of the local rule. And the court, and the court struck their counsel for that. And the
Was
U.S.
that
Supreme
counsel pro hoc vice, or was that not?
I'm going to get to that. The answer is the counsel. I want to be assured my answer. Yes. And I'm going to read my conclusion, because it doesn't say pro hoc vice, but I'm going to read you a part of it that says, During the hearing, however, the magistrate judge revoked Lowe's, that's the attorney, provisional acceptance. So I believe that's the parlance of pro hoc vice, but Your Honor, I'm pretty sure, but I'm not 100% sure. And then the following week, et cetera, and then the revocation occurred. And yes, it was. So the Supreme Court holding, government conceded that Gonzalez's Sixth Amendment right was violated below, where the court denied pro hoc vice admission based on perceived violations of a local court rule.
All right, so pro hoc vice was not permitted in. It wasn't a revocation of pro hoc vice. There's a difference.
There is a difference, and both occurred in this case.
Okay.
There was both. Good point, both. So Your Honor, and there are other cases when you have the Sixth Amendment, the fact that someone is pro hoc vice status is not the determining factor. The Sixth Amendment, in terms of legal dignity, is way up here, and then the pro hoc and the local rules are down here. It's only when the violations that undergird the pro hoc vice get repetitive, get more than repetitive, but go to things that are done that aren't corrected. And the issues that I've seen in my research, Your Honor, is that they have to be the violations have to drive so much to the core issues in the case. It's like suborning perjury, putting people on the stand when they know they're wrong. Literally having objective evidence that counsel had a document in their hands, almost literally at the same time they're telling the court they don't have it. It has to be that severity to trump the Sixth Amendment. And why is that, Your Honor? Because the court has alternative remedies for if they really think that is happening. And that is going to be my last point on the Sixth Amendment. The case law is replete with the trial court having to be careful that whatever they do, even if they believe there's a basis for some sanctions, that the court look to do them post-trial so that there is not, for the trial, the bleeding in of those issues into pretrial matters. And the case law, there's a mention of that all the time. It encourages the trial courts to make sure that they're very, very sensitive to that issue. I don't think the courts are being all that sensitive and empathetic to the lawyers, but I think what they're doing is appropriately trying to make sure the defendant gets a fair trial, right? And the defendant is not adversely affected by whatever the counsel may or may not have done. But I want to be very careful and clear, Your Honor. I'm not saying that is sort of like mitigation. I'm saying, importantly, the time I spent that there was not these violations. If any occurred, they were corrected. And on Rule 14, there's no prejudice. And therefore, I conclude, Your Honor, and I would urge the court. What happened on February 18th, there were some misstatements and they weren't cured. I don't want this to turn into, and I'm not making this argument, I'm not making an equivalence argument. I'm not saying, okay, now let's turn to the Commonwealth. To the contrary, Your Honor, and I hope I've provided a factual and legal basis. I don't want any of this to continue. I don't want scrutiny of the Commonwealth statements on February 18th unless there's going to be continued scrutiny of the defense counsel. And I don't say it as a camouflage or a shield. We've got a lot to do between now and April 1st. The last thing I'm sure the court wants or anybody wants is to have something happen where that date can't be met because of whatever actions come out of this. My hope is that we all understand we make mistakes. Mistakes have been made clearly by both parties, and I would urge that the parties, not talking about the court, the parties take a breath, a deep breath, and focus on the matters that are important, which is how can we prepare to make sure that the presentations to the jury are candid, truthful, and most importantly, effective so that jury can make the best decision. There's a lot at stake here. The issues are momentous, and that is the focus of the defense. And I, again, conclude, but I would ask that I have, if anything said, if Your Honor has any concerns, I would really appreciate hearing them so I can take them on. Mr. Jackson, Mr. Urnetti, any questions Your Honor has, I would greatly appreciate it, my presentation notwithstanding. If there's still concerns with the court, we will take them on as best we can, and certainly candidly. Thank you.
All right, I appreciate that. Before I give the Commonwealth an opportunity to respond, I need 10 minutes.
All rise.
You are muted.
We're in recess. seated. We'll be back in session.
Alright, so before I hear from the Commonwealth, Mr. Leslie, I am going to take you up on your offer to ask any questions, and I may have questions for both sides next week, but actually, what I want to do, and you said I could ask questions of other counsel. So while memories are fresh, I just want to assure the accuracy of what was just said. So I'm certainly not going to order counsel to answer my questions. You don't have to, but I am curious. So we're going to start with you, Mr. Yannetti.
Yes, Your Honor.
As an officer of the court, is there anything that you questions for both sides next week, but actually, what I want to do, and you said I could ask questions of other counsel. So while memories are fresh, I just want to assure the accuracy of what was just said. So I'm certainly not going to order counsel to answer my questions. You don't have to, but I am curious. So we're going to start with you, Mr. Yannetti.
Yes, Your Honor.
As an officer of the court, is there anything that you dispute that you just heard from Mr. Leslie? And what I'm particularly concerned about is what you knew or what you didn't know.
You know, what he said was entirely accurate.
Okay? Mr. Jackson, same questions.
No, and I would simply elucidate with regard to the February 6th sidebar comment. As I look back at I didn't remember making the comment one way or the other. I didn't remember that sidebar.
I did.
Well, I'm sure the court did after it looked at the transcript.
No,
I did as well
no,
after I
no.
looked at the
I
transcript.
did long before I looked at the transcript.
Right. The context of that, what was in my brain when I said we don't have anything else to give, which when I reviewed the transcript, was very clearly the federal batch of information, what we refer to as the federal dump. I did not have in my head at all emails, communications, things of that nature, the small...
Invoices, payment.
No, nothing. Because the context of what Mr. Brennan was talking about being frustrated about were his TUI requests concerning the federal batch of information, and that's when I was making the additional statement. We don't have anything that they don't have concerning the federal information and the background information for the ARCA experts. That was it.
Your Honor, if I could, this is the...
Nope.
Okay.
Hold on. Ms. Little, it was just thrown on you that you're responsible for all discovery. But the same question, you, and again, you don't have to answer, but is there anything that you dispute in the accuracy of what Mr. Alessi told me about what you knew and what you didn't know and when?
No, Your Honor, I would just add that as soon as the court issued the order, I obviously was not in court that day, but as soon as the court issued the order that ARCA reciprocal discovery be provided, I gathered those documents and I provided it. So that was the, I guess, prompt for going to look to see if we could satisfy the 10 things that were outlined by Mr. Brennan.
Okay. So I'm going to hear from the Commonwealth now. It does not look like we'll finish this today because we'll be ending around 4 o'clock. But I will hear you, Mr. Brennan.
Attorney Alessi ended his argument talking about the Sixth Amendment and discounting repeated or repetitive violations. When you consider the conduct of this case, you should consider the history of the case. including repetitive violations, 3.6 violations, protective order violations, and then discovery violations, representation violations. The defense in the first trial attempted and successfully did portray ARPA witnesses as wholly independent, presented themselves as oblivious to the nuances of ARPA, left the impression that there was no compensation, no bias, no collaboration. They postured the information that they gave in advance of the second trial, and I'm going to get to the timing of that. But it ignores entirely withholding this information before the first trial. The defendant presumed innocent has a right to a fair trial, and so do the people of the Commonwealth. It is clear from a reading of the transcripts and the records and the posturing materials that there was information that showed that ARPA was not wholly independent. This information was known to the defense, and for whatever reason, perhaps a strategic advantage was not provided to the Commonwealth, the court, nor the jury. Mr. Attorney Alisi talks about the Gonzalez case. In that case, there was one attorney to cross-examine a witness, which is protocol. Another attorney passed a note, a minor violation of a court procedure. That is like a raindrop in a hurricane. We have a code of ethics and rules to ensure a fair trial for everybody, both sides. Coming in at the last hour and providing information when the avalanche has started is not enough. This isn't just about Rule 14. My effort with the ARCA witnesses from the beginning, and I've been clear and consistent, is not to preclude them. It is to get fair discovery that we're entitled to. I did not know before a few weeks ago what the defense had known. I did not know that there was conversations and efforts made between them and then inevitably compensation paid. I didn't know that, but I certainly suspected it. I saw Your Honor's questions before voir dire, during voir dire, after voir dire. I remember the conversations sidebar. And those questions were right to the point. And when we were sidebar, I specifically mentioned, I don't know, a voir dire is inconsequential. I don't know what to ask. I can't send them back home to get their records or their emails or any billing. All of that was denounced. All of that was portrayed as baseless. But the court had questions. I had many of the same questions. It is not a surprise that we start to scratch off the tip of the iceberg. It is not complete. There is a murky relationship between the defense and the United States Attorney's Office relative to these ARCA witnesses. And there is a very unclear relationship as we stand here right now between the history of interaction between the defense and these ARCA witnesses. You can see from the emails, while there is some information provided, there are gaps. There are enormous gaps in time. The pause moment on March 24th and then reinitiating on May 5th, where ARCA is actually billing the defense for their works before the voir dire. There had to have been communication between that time that rekindled this relationship. There are two requests that are mentioned in the emails. We didn't get all of those responses. And so we do not have an affidavit from either counsel or any of the counsels. We did not hear a word from any of them. According to Mr. Alisi, what you should do, what the court should do, is go to the federal government and ask
So
questions.
just to be clear, I am not having ex-parte communications with anyone about this case. So I'm totally rejecting your request that I do that, Mr. Reese.
It wasn't a request, Your Honor.
You suggested that I call them.
No, I said if Your Honor wanted to do that. I didn't suggest that Your Honor.
I'll move on, but the point is it is not incumbent on the court to provide the proof that the defense was given the opportunity to bring in today to clarify the record. Instead, it is the typical 101, blame everybody but themselves. There's no acknowledgement. There's no contrition. And there's no confidence that we are going to get all the materials that we're entitled to. To suggest that ARCA's position did not change. It did change. Their opinions did change by the time they reached trial. It is not that the defense brought out that there was an expert in lighting or crashes happen at night. It is the bias, the relationship that is critical, and that was hidden from the court, the Commonwealth, and the jury. It is the bias and the leaning towards one side that was not disclosed. It doesn't help the first trial to disclose it last week or 10 days ago. So let me offer a quick history. It is true, when I first spoke to the court, I believed the documents provided by the federal government, and I did correct that record as soon as I learned before court ended for the day. January 30th, 2025, the United States Attorney's Office responded to one of my two requests. They provided billing, including ARCA billing. There was billing for their reconstruction, but there was no billing provided for their preparation, voir dire preparation, travel expenses, trial testimony. That information was provided to both sides on January 30th, 2025. It seemed at that point that the federal government was being at least a little more responsive, although not directly. No bills other than what the ARCA experts did in putting together their demonstration and their accident reconstruction. February 11th, I filed on behalf of the Commonwealth our motion to exclude the ARCA witnesses. On February 12th, the United States Attorney's Office gives us new emails. And those emails were between the defense and the United States Attorney's Office regarding their request to use ARCA witnesses at trial. It's not a surprise that on February 13th, on the heels of these more productive disclosures by the federal government, we then received the disclosures from the defense, which are the emails regarding conversations between Attorney Jackson and Dr. Wolf, and the invoice for billing. Now, I did misspeak, I corrected it, but it is not the source of that information. It is the substance of that information which is critical and relevant. It is that information that should have been known to the court, the Commonwealth, and the jury at the first trial, and it is also that information when you compare it to the representations that have been made prior to trial by the defense that has import. Before, and I'm not going to belabor this and go through the comments, most of them again, but it is important before I get to the representations. The court does consider pro hoc vitae. We have one licensed attorney in Massachusetts who's carrying 3 pro hoc vitae attorneys with the request for a 4th to ride on that same license. There is a responsibility, respectfully, to Attorney Yannetti. He's a fine attorney, an excellent attorney who I admire. But there is a responsibility so that there are not a number of pro hoc vitae lawyers doing different things and then later plausible deniability. When we send emails, if I should miss one person on an email, I will receive an email telling me that make sure everybody gets every communication. I've been corrected or redirected many times when we've left somebody out on a communication. Pleadings are signed by all parties. They come through the bar card on that table. And so to try to parse or mince or put a slight on words to suggest that things are done independently and there's no responsibility for the defense when a representation is made that's inaccurate isn't enough. It doesn't assure that in the future it won't continue. Now, Mr. Alisi said there were rules of the road. This was before his time and mine, but I've read the discovery. There were no rules of the road. There was a protective order. And the protective order was clear that there was no discussion outside of court about the federal material. And there was nothing in the protective order or direction from the U.S. Attorney's Office that the Commonwealth had any right or privilege to contact any witnesses. Everything is done by the book, by regulation, through TUI requests.
So I have to say, I've never seen the protective order. I received a stack of discovery that the federal authorities were kind enough to get to me in advance of trial last time, because Mr. Jackson had told me he understood that I was operating from a place that I didn't have enough knowledge, essentially, of what was going on. So I received those 3,000 pages plus. I did not receive a protective order. I don't know that I'm entitled to it, but it would be helpful. I don't want to take it if I'm not entitled to it. I don't know what the parameters are.
Your Honor, we have a copy of the protective order. I did ask full counsel if there was any limitations to it, and I don't have a certain answer. What I'd like to do is
Call over
inquire.
there, please.
Yes.
All right, if I can have it, I'd like it. It would help guide me through this. If I can't have it, I'll just go with everything I've heard.
May I have a moment to speak to counsel?
Sure.
Thank you, Your Honor.
I'll need to call the United States Attorney's Office and get an answer for
All right, I appreciate that. Sorry to interrupt.
And so the portrayal that there was a rules of the road, there was no such rules of the road. Neither Attorney Lally or McLaughlin ever contacted any witnesses directly because they understood that that was precluded. And so there was not an opportunity to call or discuss or have conversations, share direct examinations, or have emails with these witnesses. In fact, it's underscored, isn't it, by the emails that we received where Dr. Wolf replies in the 24 saying U.S. Attorney's Office essentially told them to hold off on communications. It doesn't seem like that would be a very clear rule of the road to have independent conversation with these witnesses and then be cautioned that that no longer was viable. And so inevitably, it was the understanding that nobody would be speaking to the witnesses. And I did see in the transcript, in the voir dire, where it was asked, were you available to the Commonwealth? And the witness said yes. I don't know any basis whatsoever for the witness to suggest that there was any invitation to speak to them. And so what we have is we have witnesses that were wholly portrayed as independent. When we look at the testimony, it was represented many times in court, leaving the impression that the defense had no access and no special relationship with the ARCA witnesses. On June 5th, 2024, day 26 of trial.
What date?
Day 26
You
of
know
trial.
that, but what date?
June 5th, 2024, discussing scheduling and voir dire hearings, the defense said, I provided everything we have. I can't make up discovery. I mean, I got a report. And everybody in this group knows why I can't provide additional discovery for ARCA. Everybody knows they've got what I've got. Your Honor asked, I haven't. If you can't, that's fine. So not everybody knows, and I make those decisions. Response, certainly, certainly. You're the one who needs to know, and I thought you knew. The federal authorities will not allow me to interview or ask for additional information from anybody in their world. So I have nothing. I've got a report. He's got the report. That's it. I'm going to start asking questions on the report. That's it. He can cross the report. So as many times as he says, I don't know what they're going to testify to. Yes, you do, because they're going to testify to the contents of the report. And those are definitely questions I'm going to ask, so I've got clean hands.
All right, so you're reading from a transcript. As you know, there are dozens of transcripts. What's the volume number? There's Dave. I'm sorry. What's the volume number and the page number?
Day 26 of trial, page 248 to 250. I will get a volume number for the court.
That's okay.
This seems to directly contradict the theory that Attorney Lisi has been promoting today of the rules of the road. This does not suggest that ARCA is open for business and private discussion and consultation and payment. It says the opposite. It says the opposite. The federal authorities will not allow me to interview or ask for additional information from anybody in their world, so I have nothing. And so this presentation today by Attorney Lisi, suggesting somehow that this was open and notorious, is not backed up by the defense attorneys themselves. The June 10th hearing, we've already been through it. I won't repeat it. but those comments are important. I think what stands out about the prior hearings, and I say that I think that there's a murky relationship that we have not done more than scratch the surface of, is Your Honor may remember that the defense noticed 3 experts in ARCA, including Mr. Klein. When we get to June 10th, Your Honor is asking, regarding the 3 experts from ARCA, and this is June 10, 2024, trial transcript 28.
Hold on one second, let me grab that.
I believe it's page 12.
Okay.
And you were asking about the 3 experts from ARCA. And you mentioned, notably, I can't tell who does what or what the basis of the opinion is. And when you look at the ARCA report, there's no delineation on which of the 3 experts did what in that report. You can't tell what role each of them played from the report. And so if we only had the report, we wouldn't know which of those experts to call. And so when you continued questioning, you were told, well, you said, so I'm to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand. And Mr. Yannetti said, that's essentially it. He gives some detail. As mentioned earlier, we've spoken to them only for the purposes of coordinating their testimony and background. The important point for this particular point is that the defense inevitably calls 2 witnesses, Mr. Wolf and Mr. Rentschler. And when they only call Mr. Wolf and Mr. Rentschler, there must be a reason why. Because you can't tell from the report who did what. They noticed 3 experts. So there must be conversations with somebody explaining the witness's role or why only 2 of those 3 witnesses are important for the defense. And so it is clear from the absence of information, there are much more communications that are expected to be in existence that have not been provided. On June 18th, 2024, the voir dire hearing. The court asks, well, I thought that you would
Page,
help.
I've got the transcript. What page you want? Do you know?
No, but I can.
If it's just your notes, that's okay.
I can pull it up, Your Honor. Page 4, line 11, the court asks, so the understanding of the voir dire is that this is for the Commonwealth's motion to exclude this testimony. All right, that's what we're here for, the Rule 14 violation. And Mr. Jackson says, is that the same with Dr. Wolf and Dr. Rentschler? And the court says, well, I thought that would help both of you. The Commonwealth has nothing on that, and you say you haven't been able to even talk to them at all about this case. And the answer is that's correct. Now, refraining from my opinion and characterizations, unlike the defense, I think that the transcript speaks for itself. I'll let it speak for itself. when we continue in the voir dire hearing, page 71.
Okay?
Line 4, importantly, were you hired by the defense in this case? No, sir. Before this morning, when you walked into court, had you and I ever met face to face? No, sir. Now, this illustrates an important point. That is technically true. But what impression is that making to the court and to the Commonwealth? Is that a genuine impression consistent with reality? Line 20, the person to my left, the female to my left sitting here, have you ever seen her before? Nope. Do you know who she is? Yes. And so there is direct and indirect commentary, questions, presentations that reinforce that the defense and ARCA are wholly independent from each other. This is also consistent with the representations regarding payment. There are questions, voir dire, and at trial, about whether or not the witnesses were ever paid. It may be technically true they were not paid at the time they were asked the questions, but if there is an expectation of payment, it is a promise, reward, and inducement. It can show bias. There's nothing wrong with paying an expert. There's nothing wrong with going over a direct examination with an expert. There is nothing wrong with talking about particular questions with an expert. But when these experts are being portrayed a certain way, that they're independent, that there is no evidence or information about them, then it is not a fair representation. It is not an honest representation. Now, it wasn't until Your Honor asked today that we even knew that the defense paid this bill. When you look at the bill, there's some things that stand out. There's a tax ID number, an invoice dated July 12, 2024. It's addressed to...
Hold on 1 second, please. Okay?
It's addressed to Attorney Jackson. And the position that the defense takes, Attorney Lisi takes today, is this came out of the blue that they had to pay. Apparently, everybody in the know knew the defense was paying for this expert, other than the defense. ARCA experts knew. Dr. Wolf knew. Dr. Rentschler apparently knew. The federal government knew. When you look at the bill, there are things that stand out that are so notable that you can't go back and try to twist them or change them. Look at the first entry of May 1st, 2024. That is before June 10th. That is before the representations that there was no intention of compensation. Apparently, the witnesses they were going to call expected that they were going to be paid by the defense, or they wouldn't have been keeping track of their time back on May 1st, 2024, participating in a telephone call with Alan Jackson. And so the March 20th email asking for an engagement letter and a retainer, and then the 24th saying we need to take a step back because of the U.S. Attorney's Office.
22nd.
I'm sorry, 22nd and 24th. There is obviously more communications because the relationship re-engages at least on or before May 1st, 2024, and these witnesses understand that they're going to be paid by the defense. And as I mentioned in the materials we got from the United States Attorney's Office on February 12th, there is no billing related to prep for voir dire, travel, trial, none. So the only people who were surprised that they were paying the witnesses, apparently, was the defense themselves. And then before that June 10th hearing, where the representations were made, there's a June 9, 2024 phone call. Another participated in telephone call with Alan. And then we see before for the voir dire testimony, there is billing to the defense, which is now we know paid by the defense, prepared for voir dire testimony, June 17, 2024. What we don't know is, in the preparation, was there any conversation with the defense? Was there any emails? Were there any documents? Were there any outlines? Was there any discussion about the potential testimony, or is this solely the preparation of Dr. Rentschler on his own? On the same date, 3 hours billed by Dr. Wolf, prepared for testimony and hearing. Now, they felt inclined and comfortable billing the defense for it. Was there any interaction or discussion between the parties? We don't know. This was the time that the court gave the defense an opportunity to bring in their product, their receipts, the emails, to elucidate, illustrate, demonstrate, prove what the relationship was. We don't have anything. We have nothing more than we did last week. On June 18, 2024, a round trip to Norfolk Superior Court by Dr. Rentschler, and also separately for his testimony, 8 hours billed, 12 hours for Dr. Wolf billed to the defense. June 21st, Dr. Rentschler prepares for his trial testimony, bills the defense, 5 hours. Again, we have no idea if that includes in any way correspondence, communication, interaction with the defense. June 21st, Dr. Wolf, the same, prepares for trial, 6 hours. June 23rd, Dr. Wolf travels to Boston for trial, significant delays, and then Dr. Rentschler on the 24th, round trip, Norfolk Superior Court, 11 hours, 6.5 hours respectively, billed to the defense. Now, it's hard to believe these witnesses would put forward money and expenses and travel without some understanding that they were going to get paid. It is hard to believe this company, especially after receiving an email about engagement and retainer, especially after having conversations, collaborating on their potential testimony, it is hard to believe that they would come to Boston, spend their time and their own money to do this, to just simply send a bill later with no expectation of being paid. In fact, it's a very specific accounting of their time. And when one accounts for their time, it's because they need to have a contemporaneous record so they can get paid for that time. Also billing for wait time and travel, testimony at trial on June 24th, and then there's expenses for June 18th and June 24th. Specific expenses, $1,749, $1,932. So they are keeping very careful track of the bill that they send within 1 month of the defense that gets paid, that Commonwealth and the court never knows about. Talking about correcting a record. And so this $23,925, we find out today, it was paid by the defense. We hear that there was a conversation with the federal government. We have no affidavit, we have no witness, we have no writing, no email, no correspondence, nothing to support or put in context the conversation, nothing. Nothing. And so when you look at the story on this bill and the timing of it and the details of it, we know that we are getting a fraction of the story. A fraction. It's not enough to blame the court, blame the Commonwealth, blame the U.S. Attorney's Office. There's some accountability. In addition, when we look at the totality of representations made in court, we also, at some point, are going to address the Commonwealth's position of violations of 3.6, separate motion. It's interesting that after the last court hearing, well-known reporter, very reputable reporter, Christine Rex, asks Mr. Jackson about paying the bill. And what I'd suggest, more 3.6 activity. Quote, no, of course not. That was the position last week. So what we're left with is we still don't know the relationship between the defense and ARCA. We don't know about the impact it had on the first trial. There has been these multiple representations that ARCA was independent, they had their opinions, and they were exculpatory. ARCA's opinions changed. There were 4 opinions. And if you look at their report, and I'm not going to read it for the sake of the press and the public, we'll have a trial, and we'll vet it at trial. But when you read the report, clearly the representations made about that report were extended at trial. And the question's going to be, why? Why did they improve? Why did
Any
the...
particular page you'd like to read without citing?
Yeah. If you look at the first page,
Yes.
yeah,
You don't have to read any of it, you just tell me the paragraph.
Yeah, it's just the first paragraph that lays out their findings.
Thank you very much.
and actually particularly note number 4, and both publicly, repetitively, but also at trial, the parameters of that were extended substantially. There is a summary again at the end of that report, substantially says the same thing. If you look at the last page,
Okay.
which is signed by all 3 of the experts, Mr. Wolf, Mr. Renshaw, and Mr. Klein, says essentially the same thing. So we would be oblivious if we stood here and said that the relationship between the defense and the experts, there was no relevance to bias or motive or desire to please, because clearly there's a change, there's an expectation of payment, there's communication, and to suggest that an outline was provided so close to the testimony, therefore it shouldn't have been shared. It isn't just what's in that outline. It's the fact that they have the relationship. Attorney Jackson may have brought out that accidents happen often at night. It's not the point. The point that the ARCA witness is willing to forego that information as a benefit to the defense. That is the heart of what is missing and what is hidden. And so there are a number of instances, 3 of them, in the outline where the ARCA clearly is trying to accommodate the defense. And by representing to the court that there is no relationship, the hands are clean, they have no information, is not only not accurate, it is misleading and unfair. So we know there is more. The question is, will we get it before trial? I have another TUI letter going out this week. I don't know how long it will take to respond to it, and the TUI letter is not going to be thorough and complete. It's just not the way TUI works. And so we are in the same spot. Well, actually, we're in a better spot. We know now about the relationship. We know about the potential bias. We know about the payments, but we don't know the full scope of it. And so we are entitled to that information. We don't know what conversations, communications the defense had with the ARC experts that the federal government doesn't know about. Over the next few weeks, we're going to attempt to get more information, but we will never have an accurate accounting unless it's compelled. Your Honor has mentioned the sidebar,
Which one?
the most recent one.
Okay.
I am not trying to be overly critical of another attorney. I'm not. You can laugh, but I'm not. It has been my effort to get Rule 14 material. It has been my effort not to exclude ARCA witnesses. It has been my effort to try to achieve fair play. There's been no other way to compel any information other than to file motions in this case. And it is not incumbent on the government to fight for this information. We're entitled to it. We're entitled to it. And at this point, we have no confidence whatsoever, none, that we're going to receive the information that we deserve.
All right, thank you. Mr. Leslie, very briefly, if you have something.
Yes, thank you, Your Honor. I'll be very brief. And I hope we get an opportunity to have a more fulsome response, but I'm going to be very brief on the key points. Attorney Brennan focused a lot on the invoice. As I said, I work with experts all the time. The experts keep track of time. They had historically been paid by the government. There's another completely rational, more probable explanation that they had been retained by the government. They were being paid by the government. They maybe at a certain point didn't know who was going to pay their bills because they turned out they were going to providing testimony. That is a whole different issue, what they expected to be paid and by whom from what the defense expected. So two things can be true. It can be at some point they thought they were going to get paid, but up to that point they were being paid by the government. And the entries, all that Mr. Brennan went through, particularly the early ones, there is zero evidence before the court on any basis that they expected on those dates of those entries that they were going to be paid by the defense. And it's very important because Attorney Brennan spent most of his time on that invoice. With regard to the comment he made, and this is the problem when we don't have notice, like I provided a notebook so everybody could see it. We don't have some of the things that Mr. Brennan was referring to, but he referred to, of all things, Mr. Jackson's response to a reporter. We're here talking about communications to the court. But to be clear, the reporter asked, did you pay for testimony? Did you pay for testimony? Mr. Jackson, of course, said, no, I paid for their time.
Did he say I paid for their time?
Pardon me?
Did he say I paid for their time?
Mr. Jackson?
I said the words, of course not. Did you pay these witnesses for their testimony? And I said, of course not. If the court were to ask me that question today, I would respond exactly the same way.
All right, so you just told I paid for their time. That
No,
was not said, right?
That was not said, but I'm saying there's always some inference about what he said that was said, but that was his response, that was it. But it was the premise of Attorney Brennan was what Mr. Jackson said to the reporter was different from what you've heard in court today, and it wasn't. It's important to be accurate. The other things that I'm going to go through quickly is it kept stating that there had to be a belief that they were going to be paid by the defense. There is no evidence whatsoever for that because it didn't exist. So now with regard quickly again to the other topics. Attorney Brennan talked about 3 witnesses, right? And he said he was, I believe I took it as clearly inferring 3 ARCA. Your Honor can go back to the transcript. It was Dr. Russell was the 3rd one.
Oh, I thought it was the 3 ARCA people. I
No.
will go back to the transcript.
You can go back to the transcript. Earlier on, there was a discussion, way early on.
Who is Mr. Klein?
He was a 3rd ARCA expert that was involved for the government, right? And then he stopped, and we didn't retain him for testimony.
Okay.
Let me be clear on what I mean by retain. He didn't testify.
It's been a long day.
I understand. I'm trying to answer your question, Your Honor.
I know, and I realize that you just said something that you want to explain. Go ahead and explain.
Right. So what I'm saying is, in terms of, I'm going to take back the retain. The point is, there were originally 3 ARCA persons on the report that we got from the government, right? Rentschler, Wolf, and Klein. We only went forward with the testimony of Rentschler, and Wolf. And that's what I want to come to, Your Honor. The whole emphasis was that the Commonwealth had no notice that we were going to use experts. Your Honor, the voir dire was the notice. And my point was, I didn't say that there was no bias. What I said was, once you decide you're going to use an expert, right, you're going to be having them testify. Anybody could claim that that testimony is biased. But the point is, Your Honor, that the allegation that somehow mysteriously this third person that was being discussed, and clearly the inference was that we were misrepresenting Steele about which ARCA witnesses because we weren't talking about the third. The third was Dr. Russell, and you'll see that in the transcript.
Okay, but when I said you expect something, whatever I said, you expect me to believe that you are calling 3 witnesses whom you've never spoken to. When I had that discussion with Mr. Unetti, that's what I meant.
Thank you for bringing that up, Your Honor. And that was just ARCA. That was nothing to do with Dr. Russell. But here's the important part. Attorney Brennan didn't read the rest of it. You're to believe...
Okay, so where are we? Are we the June 10th?
Yes, please, Your Honor. June 10th, that's exactly right. That's exactly right. It was June 10th. It's important. He stopped
So it's
reading.
page 12.
Yes, thank you. So on June 10th, so you're to believe, this is line 19, so I'm to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand here. Here's the response in its total. That's essentially it. We've spoken to them. So it's not like it wasn't disclosed there was a conversation. It was. We've spoken to them only for the purposes of coordination of their testimony and their background. We've not been able to interview them regarding their findings, which are outlined in detail in the reports. Your Honor, that's 100% true, because
I read that earlier.
Right, but Mr. Brennan just mischaracterized it again, because that is 100% true. He made it seem like that was an untruthful statement, and I know Your Honor gets it. The other last 2 points, Your Honor. Attorney Brennan talked about that the ARCA experts improved their testimony. My point, Your Honor, was their opinions never changed. Whether they improved is a characterization, but their opinions did not change. And that is very important. And the last point, Your Honor, goes to the discussion that Your Honor was having with the questioning of Ms. Little, Mr. Jackson. I want to be very clear on February 6th, and this is going to be my very last point. When Your Honor asked the questions on February 6th, and Mr. Jackson responded about the discovery, and I said to you that Ms. Little was the one handling the discovery. And I spoke with Ms. Little, and I spoke with Mr. Jackson, and they're going to be completely available for any questions that follow up on this. I asked Ms. Little during the break. She wasn't here for that February 6th. She obviously didn't hear the sidebar. But I said, when you learned of what the Judge Cannone was asking about, I said, in your head, what was going on and what came to your head? Because I said Mr. Jackson didn't make any knowing misstatement because he had no recollection of any of those March emails. So I asked Ms. Little, who would, between the two of them, would, if there was any recollection. So during the break, I asked Ms. Little, I said, Ms. Little, when you heard, and got the order, because that's the first she knew of the inquiry, she gets the order, I said, when you got that and you saw that you had to turn over discovery, when you read that, did it come to your mind? Did it come to your mind that there are these March emails? And she said, no. I didn't recall them. I didn't remember their existence. And what I did was I knew we had to turn over discovery. I then went back. I rediscovered those emails, and that's how I had recalled it. That is important, Your Honor, because there has to be a knowing misstatement of fact for 3.3a. So not only did Mr. Jackson not know at the time Mr. Jackson made those statements and recalled those emails, Neither did Miss Little, who was the keeper of all the discovery. And that is my last point, and I will conclude this way, Your Honor. Attorney Brennan conflated Rule 14 issues with the 3.3A1 issues. They are completely separate. I am not here today, Your Honor, to take the position that the defense is in perfect compliance with Rule 14. We're not. But that's a whole different question. A whole different question from whether the attorneys are in compliance with 3.3A. And I would urge Your Honor, as I know you will, to keep those distinctions as we go through the matter, because conflating them is not proper for the analysis. And my last is a citation of law, Your Honor. It was said that Gonzalez involved a very minor issue. Attorney Brennan is correct. There was a minor issue in Gonzalez, but the Supreme Court went through those things that could rise to it, and I'm going to give you another cite, Your Honor, which is United States versus Diazzi, that involved a lot of serious issues with regard to conduct of counsel. They were not pro hoc vice, but it's 807 Fed 2nd 12 First Circuit 1986, where Your Honor can read it as to what were happening. The attorney's conduct was deplorable. And yet, the court held that you could not disqualify them because of the Sixth Amendment. And my last point, Your Honor, is when you do a Sixth Amendment analysis, whether or not the attorney at issue is pro hoc vice or not, is not weighty in the determination of balancing the Sixth Amendment. It is not. In the abstract, Your Honor, in civil cases, is it easier to knock out a pro hoc vice? That would be absolutely correct. But when it comes to a criminal case where a defendant, their choice of counsel, that is a much different analysis with the Sixth Amendment. So I will stop there, Your Honor, because you said to be brief. There would be more I would have to say, but those are the highlights for the moment.
Anything, Mr. Brennan?
Very briefly, Your Honor. My arguments to the court have always been focused on Rule 14. The verbal gymnastics that counsel engages in to use words like misrepresentation to distort reality is extraordinary. So let's use the defense words themselves. If you look at docket 505, which was signed in a pleading.
That was filed
On
late, right?
February
Or
6th.
Saturday or something?
February 16, 2025. This sums it up, really. And this is signed by Attorney Jackson, Attorney Alisi, Attorney Manetti, certificate of service by Attorney Little.
Was it signed by Ms. Little? It's not,
Ms.
right?
Little has
It's
only done a
maybe
certificate of
authored
service.
by- Okay.
She did not sign it. It was signed by Attorney Jackson, Alisi, and Yanetti. And this is the defendant Karen Reed's opposition to Commonwealth's motion to exclude employees of ARCA LLC. And here's the representation they made. Not my words, not a misstatement, not a distortion. This is their words. Now comes the defendant Karen Reed, Ms. Reed, and respectfully request that this honorable court deny the Commonwealth's motion to exclude the expert testimony of employees of ARCA LLC, namely Danny Wolf, PhD, and Andrew Rentler, PhD. Here's the important part. The Commonwealth's motion to exclude these exculpatory expert witnesses who were not hired or paid for by the defense is not made in good faith and is a desperate and transparent attempt to keep exculpatory testimony of neutral expert witnesses from reaching the jury in this case. I know Attorney Alisi no longer likes the word retain, but that retain word has import. There's a reason he said it. Their words, their motion. This is no different than the tone of representations made February, last June, May, and before. Thank you.
All right. So we're back here next week. I believe we're back here Tuesday, Wednesday, and perhaps Friday. Is that accurate?
Your Honor, may I speak to Wednesday, please, the 5th? As this court may know, Mr. Jackson, myself, and Attorney Weinberg are scheduled to appear before the federal court
What
at
time?
9:30 in the morning.
Okay.
Could we possibly go there and then
Yes,
come here immediately afterwards?
sure,
Thank you, Lauren.
sure. All right, but we'll see you here, Jim, we have these all scheduled at 9.
We do.
Okay. All right, so we'll see everybody here Tuesday at 9. We've blocked off the day for Tuesday, Wednesday, and of course I'll let you go to federal court first, and also Friday. All right, so we'll see you next week.
One more line, please.
Goodbye.